Case diary is there.
Contracting council will not come, but it is there.
Three councils are there. Wait, we'll see. Or we'll have to retain the city. It is a difficulty.
Notice can otherwise fix it on if there are personal difficulties on Tuesday.
Okay, Tuesday.
Patch of light.
Any interim? Huh?
May it please this Lordship, I beg to mention item 33 of the Delhi League.
Item number?
33.
Yes.
On the last occasion we have
Case there is notice.
Any interim?
interim is there.
Okay. Give it.
Only journal.
Give it.
No, this was Kamru Metro. We can fix it. 10, 11.
10, 11. Interim to continue.
Highly obliged.
Or listing was on Tuesday.
Bill allowed.
Right.
But it only condition is
Yes,
that it's related to
yes.
this bench.
May I beg to mention item number 62 from supplementary list.
60.
Supplementary list.
Okay.
I am the petitioner. After vacation, Lord.
After which,
Highly
under prayer to render the petition.
Lordship, I beg to mention 39. Item number 30.
39. Yes.
No, case there is.
Yes. Yes, that it is.
Adjourn the matter before the vacate. The case council office today is
Next week.
not in
Tuesday.
flesh. Not in
39, no.
No interim.
17.
17.
of that.
I please your Lordship.
Lordship, I was
To the it is 78 days.
yes, sir.
73 days. 306.
306.
How to the satisfaction of?
Yes, Lordship.
No objection may be recorded.
CGM
No, that is there. This you need this is a wastage of government fund,
CGM
feeding them inside jail. You do not require anything after 70 days. That is 306. To the satisfaction of?
72 days, madam, this is I think, madam, this is a 60 days offense.
logging code.
It will be 60 days offense, 306.
60 days offense, then it's a 70 days already it says
Yeah.
default bail.
Yeah.
Default bail. Already in custody and I also think so. Assam police is smart police. They do the investigation at the earliest.
It will
No need-
extend to 10 years.
Huh?
60 days.
60 days. Okay. The petitioner has been in custody since last 73 days. Last 73 days. And accordingly entitled for default bail, considering the above allowed.
Part of letter.
Scan copy.
My lord. I have and all the orders. Using
Let the PP go through it. We'll do. How many days you are inside?
I am 176 days. The team has been examined, my lord.
No,
And the last
that's
6
true.
occasion, my lord, no PWZ turn up.
Victim has been examined.
Yes.
Okay, we'll take it up Tuesday.
No, let the scan copy call for.
Scan copy.
All the orders I have planning. All the
Yes, the next, but
no, regarding orders also, I have not having a problem. But regarding what are the
Statements.
materials going to be?
Statement.
That will be different. Tuesday.
17th. Call for us. We'll see on that day.
Money.
Okay, Bura, just go through it.
My lord.
We need to call for the scan.
My lord,
copy.
scan copy will call for.
What we have called it. Give it on when?
My lord, let it be 17, lord.
Huh?
17.
Let it be on 18th.
18.
18th. We'll see. See,
Lordship, seniors in leg in another court. Kindly pass over for time being.
We are calling for a case diary. Read here. It will be treated as a de-addiction camp also. Huh? Read here. When, Purva?
No, before the vacation is not possible.
Possible.
Lord.
Immediately.
Immediately after vacation, 7-11.
7-11. 4 to 9 all CD.
4 to 8, my
8,
lord.
8, 4 to
My
8.
lord, two other connected matters are fixed on 16th and one is on 17th for CD. Can it be on? 16th?
I have gone through the CD. Anyway, so we'll fix it on 17th.
Let it be on 20 with BA number 3587.
Where is the other method fixed? 18th.
On 16th,
No, you said 2 meters.
one is on 16th, that is one AB.
Yeah.
And this is BA 3587 of 2023, fixed on 17th.
1710. We are fixing it on 17.
Yes,
You
sir.
give the number.
Uh,
Along with
3587 of 2023.
3587 of 2023. This 4, 5, 6, 7, and 8.
8.
Same order.
17. Lord.
On 17. Other methods are fixed. One AP I have rejected.
Yes.
The president of the club.
Club. Yes.
And now
Today also one method come also.
these are the 4 to 8.
अच्छा नहीं है.
My lord,
There's some ABs there.
I think my lord, item number, Lord, that club matter 1%.
The club method.
Yes, my lord, that is
Let us take it
number-
on 17.
item number
Yes,
26.
yes, ma'am.
We will still take it on
Yes.
17.
Lovely.
It will be better in a BA case instead of
Yes.
today.
Lovely.
CD. When?
Not possible. Lord.
Not possible. So
Subject to
many.
lordship
Then
consider-
we'll have to sit till 12 midnight. So many fetters fixed on 8, 17, 18th, and 19th. You are late coming to the court. Yes.
10, 11.
10.
Please, your lordship. My lord, this is a 439 bail application, my lord.
CD.
My lord, the allegation is that lordship, I am a beneficiary lordship of KCC loan lord and could not repay the amount.
No. Not only that.
Yes, main allegation is against the manager lord.
I understand,
Yes.
but who forced this document? I think the manager should not be arrested. You should be arrested
Lordship,
because you. What is your name?
Ashu Hussain lordship.
Asu Hussain. What is the allegation against you? Let us see.
Allegation is that I am one of the beneficiary lord.
No, not one of the
And-
beneficiary. What
yes,
is your
yes,
conduct? Tell us.
Yes, lordship, and lordship, certain documents lordship could not
Space.
page
Asu
9,
Hussain, what have you done?
page 10
You-
lordship,
Your father is no more. Huh?
that
you,
was there.
You declared your father to be alive. There are some certificate, all forged. This is not a case for anticipatory bail.
Lordship, prior, before
BA.
vacation lordship,
Huh?
finally lordship. Because the BIO case lord,
Yes, that's why.
before vacation,
7 you have arrested. Be there for some.
before vacation.
These cases should be tried before a trial court, at least before vacation. Yes, Borua, when
My lord,
there is a nexus, not only one,
my lord,
4, 5. Let all come together.
arrested on 6-10, Lord. That will be
6-10.
after vacation. Lord.
Yes. On immediately on reopen.
9-11. Lord.
9.
May please your lordship.
Yes.
Lordship, this is a 430 bail application. The FIR starts from page number 11. Lordship, the allegation against the present petitioner is this, that the informant's husband was attacked.
You are Sanjeev Islari.
I am Sanjeev Ittari, Lord.
Against you, there are sufficient material according to the
Yes.
sessions court. So we are calling for the case. Then.
Lordship, I have a small prayer, Lordship. Lordship, the matter will be listed again after the vacation.
Hmm.
Lordship, I have a genuine apprehension, Lordship, and I am
You
innocent,
should have.
Lordship.
It should be
Lordship, I am
because the
Lordship, the allegation is
specifically
this, that
alleged serious injury, and then the learned session just found material
Materials
against you.
the story, the actual story is something different. What has been alleged is
We'll
that
see that. We'll see that.
Lordship, I may be protected, interim protection.
On
I will appear before
17-11.
the IO
you need not ask for interim protection in this court. The genuine case,
1711.
you will get it. This is not a case for
Lord.
interim,
Along with the injury report,
along with the injury.
Lordship, a date may reflect.
1711.
17.
Oblige, your lordship.
This one. Yeah.
Lost my lord. Just 7 basically, my lord.
Interim,
Yes.
CD interim call for the case diary of
Both
case diary of Dolgaon PS case number 409/2022 and also 410/2020.
oblige,
Statement within 10 days.
oblige.
When
2311.
23. CD
On 1411.
May I please?
yes.
The 438 applicable lordship will find the FIR page 11.
CD interim
Oblige.
within
On-
10 days.
2211.
Yes.
Is your lordship? 438 application.
Girl recovered.
My lord, it's on the next day immediately. With the point.
You have instruction.
Yes.
We'll take up.
My lord.
What is your age? The accused age.
18.
Huh?
Just 18.
Yeah, 18. And her is 14.
15.
Just have it. That's
Yes.
why we'll-
Yes. They were mourning only brother-in-law, husband, and recovered parents.
What is this? Yes.
This
Oh,
is
what
the transfer.
what is your instruction?
Madam, just couple of 2 minutes, madam. I would like to submit one thing. The respondent, he left the house of the petitioner.
No, that we understand. You have
Just-
argued that.
Just
We list this matter.
My
for
lord,
certain
we are not
instruction.
trying to evade the maintenance case, my lord. That is what I am like submitting. Since 2017, my client has.
No, we are
paid-
staying here. I recall.
Right.
You need not waste time.
My lord.
The condition
It
was
is
that
a salary slip, my lord. He cannot afford 20,000, my lord, at this stage. If it is possible, my lord, at least 10,000 he will be able to afford, my.
how much you can pay, tell us. A lady 125 will not stay.
My lord, he is ready to pay 10,000.
10,000.
My lord.
Okay. Notice. The stay subject to deposit of 10 rupees 10,000 before the registry, which is to be released for as the litigation cost for the respondent wife.
My lord,
Within a period of
7
days, 10 days. Registry will be open till when? Will be open? 19. Okay, you give by 19.
Oblige.
No. 19th, na? Reopening. No. In the meantime, there will be some working days in registry. Okay, you deposit in 10 days. Registry will be open.
Oblige.
Reason application subject to payment of 10,000 deposited as litigation cost for the respondent. No.
Your
May-
lordship, the
may I
report was
please, your
called for.
lordship?
Yes.
The matter may be.
Cash and mobile.
Yes.
Hello?
Report was called for earlier, lordship. That report.
What is the report?
That report not received.
So far relating to cash, okay, this should be circulated.
Yes,
Nothing
otherwise,
is- it is not a fake currency.
yes.
So far relating to the mobile,
Yes.
only question is that is it any requirement of sending into FSL or
Yes,
not?
yes, that is
That
what-
much.
Yes,
You have it, we'll have next week.
next week.
Archana. Next week. The report call for is not received. Learned additional public prosecutor submit that she will when Bora submits that she will obtain the instruction whether the shall obtain a report as directed earlier.
Yes,
List it on
1810.
18.
May I please, your lordship?
Same,
Same law.
mobile and cash. Same.
Not 15, 16 same lordship.
15, 16, same.
Yes.
You want to say something?
My senior is left another court, so kindly.
We are taking on 18. We are giving all these mobiles and cash on 18 if they fail to. Okay? Yes. Tell your senior. What to do? Bank guarantee.
Yes.
We have already passed orders that no bank guarantee, only bond.
Indemnity bond.
Bond আছে না? For Jimma, bank guarantee has been asked. We said that
Yes.
bank guarantee will should not be
Otherwise,
given, only bond.
There's a
Pass-
bar
pass
under
some other.
section, yes,
Huh?
11.
Huh?
11 of
But petitioner is not there, okay? Please, the next week. Then appears for a petitioner on call, let me. Yes.
This revision petition is preferred against the enhancement.
Has 700 rupees enhancement.
Okay, yes.
We do not find any merit in this case.
E-rickshaw puller will have
Okay, maybe.
up to 3,000.
E-rickshaw puller then should not marry, should not give birth to a children, should not send the child to the school. Do you propose that? That my child should not go to, when it was given 2,800, she was 5 years. Now she is 10 years, class 6 or 7. Court has enhanced considering into your profession only 700.
Yes.
This is not a case to be entered.
Actually, he has to maintain his old age mother. And after experience,
That is the reality of life.
that is the
Beg somewhere, have the day you ride e-rickshaw and the evening go to the railway station and beg. A beggar and monk is to maintain his wife and family. Dismissing without any scope for any future or withdrawing it. Withdraw.
May I please, your lordship?
Yes.
Kindly pass for the timing. My senior is another court.
Will issue a notice. That's all. Okay. But we do not know to this situation. Yes. Next. Decision revision.
I can remember.
Considering the materials available and record, and also considering the period of sentence, the improved judgment dated so passed by the appellate court and the judgment dated so passed by the trial. Remains a state. Steps. Yes.
Yeah, before going to the impugn order, may I take your lordship to the FIR first?
What is your problem?
My problem is that, lordship, from the initial date when I was apprehended along with the we were apprehended along with the girl by some student organization, lordship. Nothing happened. Even in the lordship.
No, what you have challenged the order of transferring the PS case from one to another.
Yes.
What is your problem?
My problem is that investigating officer is already from that period. So from where the
How you are prejudiced for this?
prejudice now, because Lordship, now they want to develop the case because their initial case was that that girl was with me at Totoma, and now they want to say that some incident happened in Terpangun. So they want
Charge
to.
sheet has already been filed
Yes,
against you.
already filed.
Yes, I
You are
am
on bail.
Yes.
We'll dismiss it after vacation.
No, Lordship, just one thing I'm stating to your Lordship, that if your Lordship observes that trial should go on, I have no problem. But they want to investigate it further.
They are having a
But-
power.
No, by the same police station they can, but they cannot transfer the case once they have submitted charge sheet.
Where is the bar?
Because Lordship,
Where is the bar?
when they submit charge sheet, Lordship, they already submitted the original documents in the before the
That we
court.
understand, but is it that the one charge sheet is filed, there is no scope for any further
So
investigation?
that is always there.
If
Even-
that is
even
always
we are-
there may be, it's not a case for stay of the, otherwise your proceeding instead, we'll examine.
Yes, can
No,
copy.
I'm only on Lordship that further investigation by another policeman, because they, if your Lordship see page number
You
29.
show me any legal bar. And your prejudice, that's all. This is not a case before vacation. When is the next date?
They are further investigating it.
Okay,
Yeah.
let them investigate, we'll take a call on reopening.
Okay.
Okay. On the prayer of the learned counsel for the petitioner, list this matter on
8/11.
8. All right.
In this case, my lord, what has happened, the evidence, defense evidence of the petitioner accused was closing a proceeding under NIA. By order dated 28/4.
Why should you what is the illegality?
I don't-
Tell us.
Why?
You want to delay the process?
No, my lord.
You want to frustrate the 138
Not
proceeding?
that, kindly
How
see,
much cost will you pay?
and already, lower court has already postponed on 2 occasions.
Yes,
My lord,
Rightly
he
imposed.
is a retired person, my lord, kindly see from the order sheet, I will show, my lord, what has happened. By the order dated, it is admitted fact that on 5 or 6 occasions, adjournment was not, he could not come, he was a resident of Samta village in the district of Nalwadi, and from page 32.
Samta village, if you say hi, Samta, you will listen Samta from your court.
My lord,
It's not a far away place.
kindly see, my lord, page 32 for a moment.
I have seen each and every place.
From the status of the case diary, my lord,
Yes.
the complainant has sought more evidence, more adjournment on 16 occasions, my lord, kindly see. He has delayed.
There has been
itself.
granted.
He has, my
But
lord,
we have not
previous
laid
occasions,
evidence.
my lord,
Matter was fixed for argument.
yes, my lord.
Then argument, there was an adjournment.
Yes, my lord, on that case, on the second day, I was appeared.
How much cost will you pay for issuing a notice to the other side?
Kindly see for the fact of the case, my lord.
No kindness, no question of
And
kindness.
in the key diary, we were, by going by
We
the
are,
key diary, my
we are,
lord, the matter was
we are
fixed. We were
guided
in
by
the,
law,
we
not
were in
by
the-
kindness.
we were in the impression that matter is fixed for argument, but from the e-post diary, my lord, will see. The matter was after 28/4, it was fixed on 2/6, reflecting that matter is fixed for DW. And on 2/6, my lord, we were present here before the court, but the complainant and the complainant's advocate were absent.
Don't
I filed a petition.
don't blame the
I am not
complainant.
blaming my lord. Kindly see,
Don't blame the
my right
complainant.
will go, my lord.
You have missed your mark. Now tell us, for issuing notice, how much litigation cost will you deposit for us, that person for whose sake has been bounced and fighting this litigation from which year?
18, my lord. Kindly see the, from 18,
From
page
2018.
from 30, page 32,
No, no,
my
we have
lord,
seen
will
it, we
reveal,
have seen it.
page 32 will reveal that.
Please answer, how much cost will you deposit as a litigation cost for the respondent to come here and for a stay? Have that instruction,
But-
20,000 on
No, no, no.
Tuesday. On Tuesday,
Can it be on 18, my lord?
18.
Okay.
If time permits, 18, we do not know. Yes, next.
The lordship.
Yes,
Lordship, this is a criminal petition for quashing of an FIR which is lodged as Bokajan PS case number 78 of 2022.
and what about this charge sheet?
Charge sheet, Lordship, one similar allegation case was filed
Uh.
regarding the same person. So what is
Same offense.
same of them? This the point is that the informant, in Bokajan PS case number 78 2022,
Hmm.
the initial case was filed back in Yeah, yeah, back in 2018, Lord,
Mm.
which is reflected in page number 21.
Mm.
So the point is that the informant Ritika Datta, she filed an FIR against the petitioner,
Mm.
and for that he was arrested, and now the trial is going on.
Mm.
Now what happened? Ritika Datta got married, and some photos were allegedly made viral. Now what happened? Ritika Datta got married, and now her husband lodged an FIR.
Mm.
Now in the Bokazan PS case number 78 of 2020,
Now, when first allegation is of 2011,
2000,
2011, 2018.
18. Yes, yes. So for lordship, for that trial is still going on, and it is in the evidence stage.
So this was prior to her marriage.
Yes.
Okay. And subsequently you have done, so she got married to another boy. And you are now sending all this to his relatives, brothers and all. Two different cases,
Lordship actually
two
wants,
different facts. Lalu Prasad Yadav.
lordship wants that photos are made viral in social media.
Hmm.
So there are other persons who can also make it viral. And in
That
the FIR,
is be a matter of trial.
and in the FIR also,
Specific allegation against you in the FIR.
no, lordship, if you come to that Bokazan case number FIR, which is in page number 13.
Hmm.
uh,
I've seen that.
yes,
Specific allegation to the brother-in-law of the victim, you have sent it. You had a relation, you had some intimate photos, you have released it. Where is the file?
our name is lordship not mentioned in the FIR, and the numbers mentioned in the FIR are not of what.
That will be the matter of
Yes,
trial.
let us call for the scan copy of it.
Lordship, humble
Why
is
should
that
we call for the scan copy? You'll dismiss it right
Yes,
now.
yes.
lordship can
Otherwise-
notice the issue. That is the humble claim.
No notice can be. It will dismiss it right now. Why should we call for the
Yes,
scan?
doctor.
Is it the
Otherwise,
right?
some of the case is made out of.
Because lordship, in the FIR, the names were not mentioned, our numbers written were not of ours. That is why humble price and notice may be issued.
Scan copies. Not no notice, most one scan copies.
Public.
Of the case diary of a important copy.
After petition,
After it.
date quantity 2011.
Yes.
My lord, we are assailing the order by which charge has been framed, my lord. Before that, if your lordship will kindly permit me to place the FIR, madam, at page 16.
Yes.
With reference to the above, I would like to inform you,
Page 60.
page 16. Annexure A, page 6. With reference to the above, I would like to inform you that today on 21/4/22, while I was escorting the arrested accused person Jignesh Mivani in connection with Kokrajhar PS case number so and so, along with Surjit Singh Panesar, APS Additional Superintendent of Police, and TSI Moti Sumatra in government vehicle. During the way, just after crossing Himoluguri Point at Kolkata district around 1:30 p.m., the arrested accused person uttered slang word towards me. When I asked him to behave properly, he got agitated and used more slang words. He pointed fingers towards me and tried to frighten me and pushed me on my seat with force. He thus assaulted me during the execution of my legal duty of being a public servant and outraged my modesty by touching me inappropriately while pushing. After reaching Kokrajhar, immediately I informed the matter to my senior officer. So this is the version in the FIR matter. Now please come to page number 53. This statement under 164. On
50.
page 53, my lord. This is statement under 164. On 21/4/22, I was deployed with my senior Surjit Singh Panesar, so and so, and Sub-Inspector Moti Kosumatri, along with one assistant for the purpose of bringing Jignesh Mivani from Lokopio Gopinath Portlo International Airport to Kokrajhar. Jignesh Mivani was arrested in connection with Kokrajhar PS case number so and so. While Jignesh Mivani was being, I have corrected myself, was being brought to Kokrajhar, on vehicle and on reaching Himologuri, I felt that Jignesh Bhimani was pushing my body. I fell. Immediately I asked him to behave himself, but he scolded me in his own language. On seeing this, my senior officer, Sujit Panesar, asked Bhimani to maintain this decent behavior with the duty of the official. Now, my lord will kindly come to page number 65, the statement under 165, 161,
One, page
page
65.
65. Lots of got it.
Yes.
My name and address are true as well. So I am presently working at the Kokrazar. I have to say that on 21/4/22, I was deployed for the purpose of bringing Jignesh Bhimani from Lokapriya Gopinath Bodle International Airport to Kokrazar, along with my senior officer, Surijit Singh Panesar, and Women Sub-Inspector Moti Bostre, along with one assistant. Jignesh Bhimani was arrested in connection with Kokrazar PS case number. While Jignesh Bhimani was being brought to Kokrazar on vehicle and on reaching Himologuri in Barpeta, I felt that Jignesh Bhimani was pushing my body. Immediately I asked him to behave. So, my lord, which version is to be believed, my lord? Now, assuming, my lord, this statement under 164 is correct, does it make out a case under 354, my lord? My lordship, I know the limitation of a revisional court to interfere in a such matter. But, my lord, one thing is very clear, that prima facie case must be made out. If prima facie case is not made out, if this statement taken in its face value does not constitute the offence, then certainly lordship will interfere. Now, my lord, be it under section 240, be it under section, my lord, 227 or 228. My lord, Supreme Court has clearly said that probative value of evidence can always be looked into. Yes, at this stage, the defense statement is not to be taken. All that court is required to do is to
Only the
examine
statements, only the
this materials placed by prosecution till that stage. Now, does it make out to case possible? Where is the allegation that I did it when intent to outrage or motive? So please have 354, my lord.
Yes, Mahan, we are inclined to stay this.
Yes.
My lord, at this stage, my lord, do one thing, my lord.
Huh?
We'll
We'll examine.
Yes.
Please, on this material, you are also aware,
My lord,
you are a public prosecutor, etc. We'll examine in details, but this is a case for stay.
my lord, already, my lord, the order dated, my lord, on 19, his distance was there, my lord. When he's required, my lord, then he can appear.
No, that is.
There
a
is no
that
problem,
is
my
a
lord, regarding his
different issue.
appearance, my lord.
What is the surrounding circumstances?
Right.
Because in 354, surrounding circumstances, there may not be eyewitness. Surrounding circumstances is very important. What is the surrounding circumstances of the prosecution witnesses? That he was sitting in the middle, both sides two lady constable. Vehicle was moving. An allegation is that I felt pushing. That will be 354. We'll have to examine. We are not saying
Well,
that
yeah.
absolutely.
But
Notice we will pass the detail order.
My lord,
my lord,
Yep,
do
yep.
one thing, my lord, fix it on after 20th November for final disposal. my lord.
Okay,
Then-
final disposal.
My
On give a date after 20th of November.
yes. Deep
We'll pass the order.
My lord.
Because we are in a hurry. We'll just dictate in
My
the
lord, no
chamber.
problem.
Issue and note. You may get it on Monday also.
My lord.
Because I have some problem in the evening. I'm taking a.
my-
Deep level.
After 20th,
After
20th November,
20, give
For
a
final
date as
disposal.
per.
final disposal, 20. On 23rd, my lord. अब कितना था ये बात?
23rd.
23rd.
23rd. You have problem. Then
20th.
28th,
28th,
my
huh?
lord. Yes.
In the meantime, we'll call for the scan.
My-
copy.
my
We'll
lord, yes.
see those things. What are the in the case there? How it proceeded. Okay.
Lord. मात्र उन्हें.
Yes.
My lord, the interim order till it enabled it.
Till return.
May it please your lordship. Correct. Here, my lord, 376 is not against us, my lord. And other sectors are flip-flop.
See the interim.
Obliged.
They give a date.
2011.
59.
Lordship, it is the petition under section 438. For the TOPS case number 130/2023.
City interim.
Published.
Pay him the money, 3,000 rupees. He is also a mason. You are also a mason.
No, I owe the money. He was to give me the money.
Yes.
It is just a case. He took advance from me. He was working on my house. He took advance, but he didn't come for work.
You are on interim. Go and give your statement. Yes. Next
Yes.
one.
Obliged, much obliged.
2011.
Maybe. Notification is grant the bar from 28.
Lordship, CD was
CD.
called for, CD not received.
City not. It is bail hearing or what?
Bail hearing.
Second time, my lord, it has grant the bar, my lord. From 4 days, my lord.
How many days?
54 days. my lord.
From Sonapur next week, any day.
These are not a case. This is AB or BA.
BA Lordship.
These are not cases. They had relation. They had everything. They decided to marry. Then suddenly he will break the house and enter into her bedroom. How many days?
54 days. CGM Kamrup.
We are reducing the cost of the state.
Lordship.
CGM Kamrup.
CGM Kamrup.
Apply.
Wait, please, your lordship. Lordship 439 bail application, lordship 38 days FR on page 14, lordship. Monasa Puja, lordship at 12 o'clock, call this petitioner called the girl, lordship. He went to that case, lord.
How many days now?
38 days, lord.
The earlier occasion, Lordship, case there was available, but medical report was called for. Lordship.
All for.
Medical report received to them.
What is that?
Nothing. Lordship.
To the satisfaction of?
SDGM Koliago.
I live.
I'm sorry to mention, I think 62 has been taken pass over without my consent. Since 5 years, my husband is giving me nothing. He is a service holder.
Ityadi. Okay, we'll have it on next week. This practice, these process the judge. We believe the lawyers.
Well, 26 that club
Yeah, please, lordship.
40 days.
When?
40 days.
Lordship, laying the
It is fixed on the 17.
70.
Yes, lord.
All are fixed on 17.
Yes, lord. Oblige, lord.
On that day, Mr. Borua just give me the whole list. We'll take up all the methods together. Because many methods are.
My lord.
Will keep 7 days behind the bar, Lordship. And
What is the allegation?
yes, 302, Lordship.
302. Series receipt. Borua.
My lord, case there is approved.
13 accused, the other accused granted bail.
That is, my lord,
Tipasa
case was the one.
case.
Type was, my lord, he was caught and he was assaulted. And that time he died, Lord.
Now, what is here?
My lord, he was also present as part of the statement of the eyewitness. Lord.
We have granted somebody.
Yes.
When?
10, Lord.
Huh?
10.
Give a copy.
Yes.
I feel very bad giving in this cases bail, but what?
He was beaten to death, Lord. The thief.
Huh?
Thief was beaten to death.
To the satisfaction of?
TGM Dorong Bangla.
And only, my lord, the postmortem report not received till now. Lord. That may be recorded.
I will record. But others we have given considering the only period of
Yes,
detention. No postmortem report is not received. Court of the view that considering the period of detention, the petitioner may be allowed to go and bail in as much as his further custodial intervention may not be necessary. If others have been granted, so I would like to the
TGM Dorong Bangla.
May I please, your Lordship. This is the first bail application for your
it is
Lordship.
there.
LCR call for Lordship, but it's not received.
LCR call for. Scanned copies of the case record call for has not been received. Registry to issue reminder. And for the same, list this matter on. Immediately
After
after
vacation. 14/11.
14.
Okay, kindly matter may be possible for the timing.
But it's can be not received in this case.
Last item. Senior is.
Scanned copy is not received. What is the offense? First it is fine.
Undertaking 302.
302. So scanned copies will be required.
Lordship, I've made inquiry, Lordship, can copy and case diary.
No,
Sometime
it has to be first come from the section, Lordship. Whether it today is possible.
Matter may be taken up as last item.
Today was not possible. We can fix it. We'll subject to, we'll verify whether it, where do you know that this has come?
I made inquiry.
Which
bench-
branch? Which branch?
their,
Huh?
bench section.
You have it. Accordingly, we'll fix the date on next week. Today it's not possible.
But my senior advised me to take some time.
Your senior's advice has been rejected. Tell him. Where's Mannan?
Yes, ma'am.
Tell him that your prayer has been rejected. It will be taken up on Tuesday,
It will be 18, Lord. 18 or
18th. 17th or 18th.
Then after vacation, he is not, will not available.
You will be here. If we reject it, then we seek an adjournment. If we allow, you are enough. Because we are also concerned that the person is behind bar, but we will have to pass an order on the,
153 days. yeah.
that's under,
She is the lady.
that we understand. But to pass an order,
As per
we
FIR
need
notice-
some material to
as
look
per
into.
FIR Lordship, no.
No,
allegation
dear,
is
it's a
taken.
charge-sheeted case.
Yes.
FIR is now not relevant.
Yes.
We'll see the other 161 statement and what is the stage of, that's why you call the scan copy. Yes.
May I please, Lordship?
Yes.
My lord, it is 30, my lord, 4B case, my lord, and out of 60 days, today, my lord, 58 days.
Totally,
Only will take first over the 30 sufficient notice. If not submitted, then notice.
okay,
Other 2 days will be, Sunday will be 60 days then.
okay. So you,
After
you
after
ha-
some time.
after some time,
We'll take it first.
Applied.
yes.
So two applicant petitioners before your lordship, father-in-law, mother-in-law of the deceased. They are in custody for 38 days. And
Where is the FIR?
FIR your lordship will
Page
find page 8. Incident occurred on 18/8/2023 and she died on 24/8/2023. She was residing along with the elder son of the petitioner, Sapphire.
Any dying declaration?
No, my. Not.
Why?
My lord,
That is the difficulty. She was alive from 10, 18. She died, na?
she died.
From 18 to 24. If you do investigation like this, then
Yes,
what to
yes.
do? You'll have to allow them to go.
Just I'm cross checking, my lord.
You
That's
cross
a
check.
cross-
See, I have
yes.
seen in other cases also, in a dowry demand, dowry death.
Yes.
She was in hospital in JNRC
Yes.
for almost 15 days.
Yes.
I think you were
Yes.
there. Nobody has even ever visited the hospital. Nurse, she could have told the nurses, there will be a medical history written in the hospital when there is a burn injury. It's a mandate of the Supreme Court.
Doctor is bound.
Why
to-
should
bound
these
to
people be inside? You have this. What is the declare any statement
Yes.
recorded? Our statement
Today or
today. We
I just
cannot
have-
allow a person to be inside
just
like this.
after some time.
After some- As a PP, you have also role. You
Yes.
should intimate them.
Lordship, in this case also I will. FIR plus 11 lordship for 27 days. Yes, 11.
What to do?
He is also a case of promise to marry and
Hmm.
thereafter my lord, take up.
BA or AB? BA.
BA, my lord.
How many days?
27 days. CTM 50.
SDM?
50.
Don't say anything, only period of it.
Only. Month. Four my lord, TD not receive on interim my lord.
Interim to continue. CD when?
20 my 2011.
20.
I want it.
35 on interim my lord. Maybe even after this type of
Okay.
on
Interim
this type of
date and 20.
23 my lord.
July. In time to con.
Interim to
36 also my lord and the same pair my lord on interim my lord.
Hmm.
23rd.
on 20.
Third.
23rd interim to continue.
Obliged, Lord.
8 also my lord.
Same.
Yes. 24th.
24th interim to continue. Yes. It is there, Goswami. What is the affair?
Is number 11 one.
Huh?
11.
Injury report is there.
Injury report is not there.
What is the CB says?
TD stage my lord. In 164 she has stated that she was implicated that on the absence of the husband accused him. And other witnesses, my lord, they said that my lord, they suspect that there is some illicit relationship going on between them, and there is also a meeting, my lord. In that meeting, they tried to
Is it item
compromise.
number?
40. 40. Goromari 83 of the
Godavari 82.
yes, my Goromari 83, my lord.
Here it is 82. That's why you are saying something. I was
Oh,
reading something.
my lord, in cost title, it is 83, my lord. I am checking well in 83. Page number 11. Page, my lord, lost me kindly see
What is
page
82?
82 is perhaps there. 82 filed by us, my lord.
Where is 83?
83 page number 11.
Page number?
11.
Okay, that's why I got
Lost.
confused. Peruse the case that he produced. Consider the material so far collected by the investigating authority. Considering the statement of the independent witnesses as well as the fact of dispute between the informant and the family of the informant and the accused, and the registration of counter case lost by the husband of the alleged victim. Is that it?
Petitioner. Petitioner.
Lost
by petitioner.
Lost by the petitioner. Petitioner. This court is of the view that no custodial interrogation shall be necessary in this case. However, it is provided that the petitioner shall appear before the IO within a period of 10 days and record the statement, and is in the event of his arrest, granted bail on the following.
Public. He received no, has no repent.
What is the material?
Material manner is lost in may finally come to the FIR part manner.
Hmm.
He is.
Miscarriage, hitting,
accused-
any report?
No, report is not there regarding that. Only matter accused number 1 and accused number matter 3, matter that is this petitioner. They had some
Okay,
relationship.
if nobody is there, why
Yes.
should you,
Lord.
uh, non-appears for a petitioner on call, might be arrested in the meantime. Who knows?
We can.
Uh, the case diary has been received, same be returned
After we get.
after, list after.
He did not receive, my lord.
Did you not
Uh,
receive?
But not on interim, my lord. But, immediately after reopening.
There is no interim order.
Yes, no interim.
Oh.
Immediately after reopening. On 8th month.
Yes,
Please, Your
Mukhtar.
Lordship. 438 application lordship, he is on interim.
My
FIR
lord,
lordship is
he's on
quite
interim,
fixed.
my lord, and in the last occasion, my lord, the direction was given to update the case diary, my lord. Is not up to date, my lord. So kindly fix after the vacation, my
Okay.
lord. In the meantime,
Okay.
As a last one, because look, earlier also I pointed
He-
out because
he's
this is
on
a matter
interim.
of 2022.
The updated case diary is not available. Accordingly, matters then adjourned and be listed on
my lord, 9 November, my lord. 18 November, my lord.
18 November,
11.
18 November 2023. The interim order passed out earlier shall continue. Pablo,
May please, your lordship.
yes,
But this is a transfer petition. Lord. In this case, my lord, your lordship was pleased to pass stay order on 25th of August, my lord. And the date was fixed there on 28th of August, my lord.
Mm.
Accordingly, on that day, when the stay order was placed before the court, my lord. And on that very day, my lord, the complainant, he submitted an application for withdrawal of the case, my lord. Withdrawal of the complaint, my lord.
okay.
But as your lordship has already passed the stay order, the lower court is unable to pass any order, my lord, because already they state the proceeding, my lord.
So we'll close it with that.
Your lordship may do one thing, my lord. Your lordship may permit the, give liberty to the trial court, allow the withdrawal. Then I will place it before your lordship, then it will be closed, my lord.
Mr. Mukhtar, learned counsel for the petitioner submits that when the matter before the trial court was listed on
28/8/23.
28
28 August.
28 August.
28 August.
28/8/2023, the order passed by this court staying the further proceeding of transfer petition criminal number 26 of 2023 was produced, 23 dated 25/5/2023 was produced. However, on the same date, the respondent wife,
Husband, man. And the wife, man.
respondent husband,
Complainant, man.
complainant has filed an application for
For withdrawal.
withdrawal
Yes,
of the complaint. However, as this court has passed an order staying
Staying,
the
yes,
further proceeding of the aforesaid case, the learned trial court has not taken up the aforesaid
Yes.
application. Full stop. Mr. Mukhtar submits that as the husband has filed a withdrawal application, the interim order may be modified.
No, no, your lordship may give
No,
liberty to the trial.
yes,
Yes.
this is your submission. Interim order may be modified
Yes.
and the court may be permitted to
Yes, yes.
consider the withdrawal application.
Yes.
Full stop. This court is of the view, is also of the view that though further proceeding is of the aforesaid case, it's stayed. However, it is made clear that the learned trial court shall be at liberty
Fine.
to consider the withdrawal application
Pass
filed by
the
the respondent hearing. Full stop. Please this matter after vacation.
Obligement.
None appears for a petition on call. Please after vacation.
May I
Will
please,
come
your
on.
lordship?
Yes.
This is an application under 389(2) of the CRPC for grant of bail to the applicant. The applicant was convicted under section 5G of the POCSO Act and was awarded rigorous imprisonment for 10 years and to pay fine of rupees
Where
5,000.
is the statements of the victim? LCR has come? Then from where we will consider? From where we will consider that there is a case is made out for the allowing this appeal. You have not annexed anything. Have you annexed? Statement of the victim girl? This
So we have
IA criminal be
order
taken up
passed in
after receipt of the LCR. 10 years. 10 years.
Yes.
10 years. In the meantime, the
Will file up.
public
And respond to also.
public prosecutor may
there is
file the
also a prayer.
prayer for what?
The prayer in criminal appeal.
No, that prayer we understand.
Yes.
Madam, just understand that your client is convicted for 10 years.
10 years.
Now, according to you, that conviction is bad. So therefore, you have filed an appeal. In the meantime, you say that since the case is bad, you should be released on bail during the pendency of this proceeding. Now, to take a determination, I'll have to have a prima facie view that you are liable for it. For that, I'll have to see the testimony of the victim or any other eyewitness, the medical evidence. Nothing is before me. A judge cannot pass order on air after LCR.
May I please, your lordship,
Yes.
as per office note 1110 to 1028, notice upon respondent number 2 is not yet complete. So your lordship await service report.
What?
As per office note 1110/2023, notice upon respondent number 2 is not yet complete. So your
Okay. In
lordship,
view of office note 11/10/2023, await service report in respect of respondent number 2 and list this matter after vacation with a updated office note.
obliged.
After. Yes.
Your lordship, interlocutory application is there, and I have prepared one compilation. If your lordship permit, may I hand it over?
This is POCSO
For 5 years only.
for 5 years.
For 5 years.
Under
And
section?
8.
Huh?
8. Maximum punishment is 5 years.
Under section?
8.
8.
Actually, judgment CV was passed on 21/4/2023.
Okay, no problem. We'll condone the delay. Who was the other side?
Other side is.
That was my fault. I know that because
No,
this
my lord,
court has created this judgment has taken. I told you
right.
sometimes this side, sometimes that
Right.
side.
So therefore, my lord, I will let them appear, then we can.
Let them appear. Will issue- If this is foregone conclusion, I will allow it.
My lord, your lordship may pass an order that we can serve the copy to learned counsel.
Okay. It's an application under Spencer. Seeking review of judgment. The issue notice returnable on give date last part of this October. No. November. Middle part after 2 weeks. Give after 2 weeks of November. Third week of November.
Can it be on the middle?
Third, there is some difference.
Yeah.
Third, 24th.
Yeah.
24th of November. Mr. Musahari is permitted to start the copy upon the respondent through the learned counsel who appeared in this in this case.
Right.
And she is also permitted to take steps to register both with AD
Right.
and as usual process. You take it because I have serious doubt
Right.
that they will accept it.
I know.
I know that,
All right.
but that is foregone. Other thing I'll say.
Madhav.
Sometimes some cases put you in it's a dilemma.
Even my position is also very tight. Because the client is harassing like anything. I have blocked his number because he used to call so much.
Two brothers. In fact, that's why I thought that okay, let this be settled for final. Nobody should be deprived.
Yes.
This your client also he
They're so adamant. And when there's a dispute between the family members,
this
It's a
is
horrible-
typical. That's why that was my thinking that
I understand.
that portion was not even established. That actually whether it is an encroachment, that is not established. This was my view. After that's why I think it was one of the judgments which was delivered, though delivered, but copy was
Right.
uploaded after many a day.
Yes.
Anyway, sometimes it happens.
Abhay. May I please your lordship?
Yes.
Lordship, that is criminal revision petition. Petitioner before your lordship has challenged the impugned judgment and order dated 3/5/2023, my lord, passed by learned principal the family court Borpeta, my lord. Lordship will find my lord impugned order at page 11, my lord. Page 11.
Let us do after vacation because we'll have to pass a judgment. We'll
Okay.
dispose it.
Other side has appeared, my lord. My interim prayer may be considered. I'm unemployed person, my lord. 16,250 rupees, my lord, per month I have to pay, my lord, as per this order. That prayer may be considered, my lord. I'm totally unemployed person.
Who is the other part?
Name has shown, my lord. Lord. Name has shown in the call list, my lord. That's right.
Why you marry? First of all, give birth to children, and you will say I am unemployed.
I'm ready to maintain, my lord, but that is this month amount, my lord, 16,250 rupees. That is beyond my capacity, my lord.
What do you do?
Unemployed person, my lord, daily wage labor. If it presume, my lord, my daily wage is 400, then also, my lord, my whole income will be if I work for whole
But you have some
month.
shops and etc.
Lordship, that is important, my lord. Page 16, my lord. Para 12, this is important, my lord. This award is only, my lord, passed on the ground of presumption, my lord, that I can earn so and so money on presumption, so you have to pay so and so. Only on the basis of presumption, my lord, this award has been
So you have been given 7,500.
7,500. Next para, my lord, paragraph 13, my lord, 8,750 rupees as area amount. Total, my lord, if it
Are you regularly paying the amount?
regularly not paying, my lord. That's why I need some, my lord, protection, my lord. I lordship may consider my interim prayer so that I can able to pay, my lord. 16,250, it is beyond my capacity, my,
How much you can pay?
my lord, 4,000.
You will have to pay 5,200. 7,500 is assured you will have to pay. Now, so far relating to the area, we can make some reduction. But other side is not there. Okay, we'll take it up on Wednesday. Okay. None though the learned counsel for the petitioner is absent, none appears for the respondent. In accordingly, the interest of justice matters can adjourn and be listed on 18/10/2023. If none appears for the respondent, court may consider the interim prayer made by the learned counsel.
Deeply applies, my
Hearing.
Lordship, I think one matter left. It is item number 57, Lordship, call is recovered.
Carl is recovered.
Yes.
Yes.
I have also one motion matter. Item 19.
What happened to it?
This is 57, Lordship. Item number.
Huh?
This is 57. Girl is recovered.
57.
There is timing matters, that will be called.
Yes.
Call it.
My lord, here in this case, my lord, the opposite party, one was the former wife. And she filed a maintenance case before the court below, and maintenance granted at the rate of rupees 8,000. Subsequently, she entered to marriage with another person, the opposite party number 2.
But you have not proved it. Why have you not brought
My
the
lord,
Qazi?
we have not given chance to prove it, my lord. We have prayed for issuing summon to the witnesses. That petition is also rejected.
Where is that?
My lord, the petition is at page 30 and rejection order at page 30. Page 32 is the rejection of the summon petition. NSR 7, page 32.
Page 32. Hard, Mr. Chigdar, learned counsel for the petition. The present application is filed assailing an order dated
My lord,
11/7/2023, passed in FC Criminal 02/2023 by the learned Principal Judge Family Court, whereby a petition filed by the present petitioner under section 127 CRPC for cancellation of the maintenance order earlier passed. Full stop. The basic ground for filing such application was that in the meantime, the wife in favor of which the maintenance was awarded had got married to another person, and in view of such same circumstances, the application was filed. The learned court has rejected such application on the ground that the petitioner has failed to establish by cogent evidence that his wife has got married to another person in the meantime. However, referring to the Annexure 6, page 30, Mr. Sikdar submits that the petitioner filed an application for summoning of witnesses. However, such order was also rejected by the court on 15/5/2023. 15/3/2023. Accordingly, he submits that he was not given proper chance to prove his case. Full stop. Peruse the material available and record, and also consider the application dated Annexure 6 application as well as order dated 15/5/2023. After perusal of the same, this court is of the view that the petitioner has been able to make out a prima facie case. Full stop. Accordingly, issue notice returnable 6 weeks, give a date till then
current maintenance. Current maintenance may be.
till then the current payment, till then the petitioner, it is provided that the petitioner need not pay the current maintenance to the wife. She has got married. You will send it back, you prove it properly. That marriage was just call the Qazi,
Yes,
exhibit the Qazi book, you will permit it, let her come first. And yes, recovered.
Search sheet has been filed.
35.
My lord, the charge sheet file, my lord, you kindly have a look page of the FIR, my lord. This case does not come under, my lord, apparently 304B, my lord.
You want to say that 30th is filed, so let me
My lord,
discharge you.
and my lord, I am paying bail, my lord, and I have forwarded, my lord, one, my lord, postmortem, my lord. This is clear, my lord, suicide case, my lord. Being husband, my lord.
Charge sheet file.
Yes.
Now we need to see on what basis we'll pass an order. CD cannot be produced because it is
It
sent
is
to
already
the
sent to
court.
the court.
Definitely, with all respect, my lord, I beg to submit, my lord, FIR, my lord. In the FIR, it is, my lord, no allegation of dowry, my lord.
FIR is not encyclopedia,
Yes,
but
my
there after investigation, charge sheet has been filed
Yes,
against
and my
you.
lord, I have postmortem report. This is suicide case, my lord.
Why don't you go there, file it?
Let him appear before the trial court. also.
Can you come to us? Can you without anything pass an order on air?
Scan copy, my lord, may be called for.
It is submitted. Sorry. It is submitted.
Kindly, my lord, I am not saying now, my lord. Scan copy, my lord, lordship may consider the next week.
You want to continuation of this proceeding? Go
No,
file
my
there.
lord, it will be definitely rejected, my lord. Rather, he will be harassed, my lord. In the next week,
What harass? I'm not
last day, my lord,
understanding.
kindly, my lord.
Harshit being
Being Thursday number 372 of the 2023, dated 39/2020.
sessions tribal.
Yes, doctor.
There is no interim order, but session court will consider his regular basis. If necessary, call for the record from the committal court. Because our courts are also like that, no?
Here your lordship wanted to
Obliged,
know whether bank declaration is there or not.
Yes. No, dear, not there. Let him go. This is the you investigate. See,
And also
for how many days?
5 days.
5 days she was in hospital.
Hmm.
Her statement could have been recorded.
Whether he is in the condition of giving statement.
Maybe that must also be there.
Nothing.
There must be an explanation. Why should we not get hold of this IO?
He is there.
This is not the only case. To the satisfaction of
Chief Judicial Magistrate
considering the period of detention and the available material stage of investigation and the material available on record, is court of the view that no further custodial detention is required.
Obliged.
Recovered. Okay. To the satisfaction of
My lord, IO
be
General-
careful. Huh?
AB, my lord.
IB.
And
Oh, it
general-
is AB. Okay, we will make it interim. Huh?
No.
City interim.
25th, madam, 11.
Must
20
oblige, my
What hearing? I have declared it. I will not take up any hearing.
Sure.
Yes. None appears for the petitioner on call. None did represent the petitioner when the matter was called on 19/9/2020. Give the LC. The present criminal revision Karagate Likhita. Karagate Likhita. The Honorable Apex Court in the case of Taj Muhammad versus State of Uttar Pradesh and others arising out of SLP Criminal 529/2023 while relying on earlier decision of the Honorable Apex Court, more particularly in Madanlal Kapoor versus Rajiv Thapar, reported in 2007, 7 SCC 625, and Bani Singh versus State of UP, reported in 1996, 4 SCC 720, comma, Agote Diva, the Honorable Apex Court in SLP under its order 18/18/2023, provided that in absence of a party or his counsel, a revision petition can be considered on merit in accordance with law. In view of the aforesaid, the present application is taken for final disposal. The present revision petition is filed assailing firstly a judgment dated 38/2007 passed by the learned additional chief judicial magistrate Nagaon in GR case number 1313/2004 under section 498A/34 IPC, whereby the petitioner was convicted to undergo rigorous imprisonment for 3 years each and to pay fine of rupees 5,000 each. To go for a rigorous imprisonment for 3 years and to pay a fine of rupees 5,000 and in default simple imprisonment for 6 months. Okay. Aforesaid judgment was assailed in an appeal, and the learned additional session judge Nagaon in criminal appeal number 31 within bracket N/2007 modified the judgments and trial judgments and order of the trial court, reducing the sentence of the petitioner to simple imprisonment for 1 year and to pay fine of rupees 1,000. Okay. The prosecution was launched on the basis of an FIR by the wife of the petitioner inter alia alleging that their marriage after their marriage as per Islamic rights, the accused started torturing the informant demanding dowry, and on such demand, father of the victim wife has given an amount of dowry of rupees 10,000 to the accused petitioner. It was further alleged that there was further demand, which was also it was further alleged that another amount of rupees 10,000 was demanded, and it was asked that otherwise she will have to admit that she had an affair with a neighboring boy. As the informant refused to admit such allegation, on 22/5/2004, the accused severely beaten her up and drove her out of their house. Okay. To bring home the charges, the learned trial court framed charges under section 498A. To bring home the charges, the prosecution examined this is a case of 2009. Examined as many as death witnesses. The informant was examined as PW. Informant was examined as PW1. He specifically alleged the demand of dowry as well as assault on her. As narrated in the FIR. In cross-examination, she reaffirmed the payment of rupees 10,000 rupees as dowry. And she, during cross-examination, she reaffirmed how the apposite amount of 10,000 was collected by her family member. PW2 is the elder brother of the victim. During his examination of Chief, he also testified that after 6 months of marriage, the demand of dowry started. An amount of rupees 10,000 was paid to the accused. He further deposed that after payments of such amount, further demand was made, which they failed to honor. He also testified that his sister was beaten up and she was dropped at their place. During cross, he reaffirmed that he has paid 10,000 10,000 to the ₹10,000 paid to Saiful to the accused. PW1 is the informant. Huh? PW1. PW nobody to assist. PW5. The victim during her evidence specifically stated that her husband along with the other family members, namely Hormuz, demanded rupees 10,000, and she brought such amount from her father from her family and paid the same to the accused. Thereafter, again, an amount of rupees 10,000 was demanded from her mother, but he could not give it. She further alleged that she was beaten up by Saiful along with some other family members. Okay. PW3 is the father of the victim. He also deposed regarding demand of dowry of rupees 10,000. And subsequently paid another amount of rupees 3,000 to the accused petitioner on demand as dowry. During cross, he specifically testified that the accused Saiful demanded 10,000 rupees from him. He further reaffirmed that thereafter another 3,000 rupees was demanded by Saiful. He also reaffirmed in his cross-examination that the victim was beaten up by Saiful and she was dropped at their place. He further deposed that state amount was paid from the compensation he received in a motor vehicle claim case by his son. You will write in the brother's evidence. Same thing. The PW4 evidence is not at all relevant as he deposed that he is not aware of the incident. PW5 is the IO who initially started the investigation. However, subsequently he was transferred. During his cross-examination, he deposed that he visited the place of occurrence and he was confronted with the statement of the victim that she has not deposed during her statement recorded under 161 regarding the demand of rupees of 2,000, which he has denied. On the basis of aforesaid material, the accused was examined under section 313 and the incriminating materials were deposed, testified by the accused, were confronted to him, which he denied. On the basis of aforesaid findings, on the basis of aforesaid evidence, the learned trial court concluded that a case under 498A was established, and accordingly, the conviction and sentence was passed as discussed here in above. The learned appellate court, after perusal of the material evidence on record, did not find any infirmity or illegality in the judgment, and accordingly upheld the judgment after reappreciating the evidence. Full stop. Full stop. The learned, this court has, after perusal of the material available on, this is settled proposition of law. The court's power, revisional power, cannot be treated as a appellate jurisdiction, inasmuch as it's in exercise of a revisional power, the concurrent findings of the learned trial court can be interfered only in the following circumstances. What are the circumstances? Considering the material available on record, this court is of the considered opinion that the demand of dowry has been established beyond reasonable doubt through the testimony of the victim, the PW, victim, the brother of the victim, PW2, the father and the father of the victim. Their testimony remained firm during the trial, inasmuch as during cross-examination they have reaffirmed their statement in the evidence. Therefore, the demand of dowry and the payment thereof has been established by the prosecution beyond reasonable doubt. Considering the above and considering the settled proposition of law, regarding the revisional power, this court finds no merit in this petition. Accordingly, the same stands dismissed. Yes, Mr. Doctor.
I have annexed the order, my lord. Page 7.
Heard Mr. N.J. Datta, learned counsel for the petitioner. This is an application for correction of an order dated 11/10.
Yes, but
2023. Full stop. According to Mr. Datta, the name, there is a typographical error in describing the court. The court, where is that?
my lord, the page 7, last paragraph. To the statute.
Page 7.
Page 7, last paragraph, my lord. Considering the above, it is provided that till final determination of the
Page
connection.
7. Right.
Last page.
Okay, just the 7. This is appeal. I want the IA.
I 984.
Huh? Huh? Kuntu. No, this is a new IA. Your new IA is IA criminal 984.
No, my lord, it is disposed of. 984
984 is disposed.
disposed of.
And which was the new IA?
And
Okay.
it-
Then why was this? They have,
Delayed.
there is a mistake. What is your criminal appeal?
criminal appeal number.
You have
Yes,
done
sir.
a mistake giving the mention memo.
Oh,
That's why the dispose of criminal appeal has come. Bring it, bring it.
Fine.
I'm here for something.
I'm sorry, but
Give a new. I think that's why this has come.
It was actually,
Hearing.
yeah, simple matter, NIAC, my lord. It has reached High Court now. Conviction been sustained in the lower court below, appellate court also.
To be here today.
I leave it
Because
to court
at
discussion.
Morning before mention, I said that I'll make a mention. I will not take the hearing
issues,
matters. I have
No issues. After vacation, my lord.
after vacation.
No issue.
One I have decided 2000.
Yes, 2009
matter,
matter.
That's
My,
right.
my,
That is also we'll have to correct on Monday on.
problem.
Yes, Mr. Das. No hearing.
It's small matter is 145 proceeding. For last so many years, it is pending before this court. 145, it has declared. It has been declared. It is my position. Evidence. Let Sessions Court upheld. It is in my favor for last 60 years. The evidence on face of it before the additional deputy commissioner. And because of status quo order, it remains. That's the whole difficulty.
I have
Last 60 years, my lord will kindly see. And he will kindly see the judgment of the additional deputy commissioner. Evidence was.
I've seen it. I did this
Evidence has
matter
been-
earlier.
Evidence has been taken. Went
Where
to
is your
Sessions
senior?
Court.
He was on like sorted. I was about to timing the matter.
Timing is today difficult. When?
Well, let it be on, I don't know whether it is possible on Thursday, last day, I don't know.
Let-
These are matters for which,
Let us have a try on Thursday.
yes, let
We'll
us try.
we'll see, try, we'll see. Okay.
If permits.
Learned counsel for the petitioner prays for an adjournment which is allowed. Please this matter. However, Mr. Das learned senior counsel expresses urgency in the
Yes,
matter. Full stop. Considering the above submission, list this matter on Thursday. Interim order was earlier.
That's the whole problem. That's the whole problem.
We'll try to have on
Yes.
Thursday if possible
problem.
after this bail.
No,
bail
no
term.
problem.
But these matters are already admitted. We could have taken up in admission. Phase. These are admitted. Criminal appeal. Yes, Mahajan, this is your. We are not, Black Law Dictionary is not before vacation.
Simple matter, 376 is there, completely contradicted. Two instances of rape.
Yes, madam. Are you ready?
Some other day.
Some other. The learned additional public prosecutor prays that she may be granted some time to prepare the brief. Prayer is allowed, please after vacation. 2022. You are outside.
Not inside, very, because bail was.
Inside.
Bail was
Give a date. Give a date. Third week of December. Sorry, third week of
November.
third week of October. November. Oh, sorry. Wait. The so if it comes, heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Madam F.H. for the learned counsel. The present application is filed for typographical error in mentioning the name of the court. The name of the court has been mentioned as Learned Special Judge POCSO, which ought to have been. It was given as Metro, na?
Lordship, production list, the copy is not with us.
Give the file. Metro, which otherwise ought to have been Learned Special Judge POCSO, Special Judge POCSO. Considering the submission, the prayer stands allowed. Instead, it was written as Special Judge POCSO Kamrup within bracket M, which ought to have been typed as Learned Additional Session Judge cum Special Judge POCSO Kamrup. Accordingly, the order dated 11/10/2023 be read along with the present
Lord.
order, and it is to be treated that the M Special Judge POCSO Kamrup within inverted comma M. It be read with the order dated 11/10/2023. If I comes, I dispose of.
Yes.
If comes, otherwise not. If it oh, if you have to send it back. Okay, if it comes, then this will be done.
If your lordship may permit
me to make a submission in item number 45.
Yes.
Your lordship has called for the LCR. The LCR has already been received by the registry of the High Court.
Okay, and
Criminal appeal number 62 of 2021.
yes. Item number, then it is not in the record. It is submitted by the learned counsel for the petitioner that after verification, she could learn that the scan copy called for has already received by the registry. However, same is not on record. Registry to verify and place the same on record and release this matter. Witness,
And in this case, I appear for the respondent number 2, my.
okay.
I am D. Kolita, my name is not reflected.
Okay. It is submitted that Mr. T. Kolita is appearing in this case for the victim or informant.
Informant, man.
For the informant. However, his name is not on registry to list his name in the court
Obliged.
while listing the matter on the net. 17.
1710.
This is what is a POXO.
Okay.
When is 18?